All right, guys, this is the one I've been waiting for. Welcome to No Opinion. My name is Terrell Hussein, and what we're going to be doing is we're going to be reading the court documents from the last day of the court trial. We're going to be picking it up where the prosecution has rested and the defense is about to hold the floor and present their case. So I don't know if you all heard the news, but there was a lot of fireworks going on, and what's been reported is the same sentences on all the networks. But before I go on, I'm going to say, hey, if you like this kind of content and you really want to know what was said in court, please like and subscribe to this channel. That is what we do here on No Opinion. Again, I don't interject any of my opinion, but I do have a bias, and I really want to know what the defense is going to use as their case, especially for this particular one. And if you really do like this content, I really ask that you like and subscribe, because what I'm really looking forward to is the closing arguments. What are they going to say they're going to leave in the final thoughts in the minds of the jurors? So, and again, I'll be reading those verbatim, no opinion interjected. Again, but my bias is I just want to know what's going on, because I'm tired of hearing about the same doggone 3 sentences all the freaking time. I want to know what they actually said and what was actually done in court. So with that, we're going to pick it up with the prosecution resting. Mr. Steinglass, Your Honor, the people rest. The court. The court is what they refer to as the judge in the transcripts. Counsel, please approach, whereupon the following proceedings were held at sidebar. The court, I wanted to confirm with you before I ask you in the presence of the jury whether you intend to present any evidence. Mr. Blanche, yes, Your Honor. We also move for an immediate acquittal. We can do that at the end of the day. I don't want to take the jury's time. We anticipate calling 2 witnesses. The first, our paralegal, 5 minutes or so, and then Mr. Costello, the court. Do you think you'll be done by 4:30? Mr. Blanche, if Mr. Steinglass talks quickly, yes. The court. To that extent, we can finish at 4:45 or 5 o'clock. We can do that. Miss Hoffinger, we need cross of Mr. Costello. The court, that's why I'm asking if you need to go longer. I'm willing to do that. Whereupon the following procedures were held in open court. The court, Mr. Blanche, does the defense wish to present any evidence? Mr. Blanche, yes. The defense calls Daniel Sitko. Daniel Sitko, having first been duly sworn and or affirmed by the court clerk, we examined and testified as follows. Court officer, state your full name for the record, spelling your last name. Witness, Daniel Sitko, Sitko. Court officer, county of residence. Witness, New York. Direct examination, Mr. Blanche. And just to kind of give you all a heads up here, I'm not going to go into Q&A and all that. I'm just going to kind of state the question and state the response without saying, because it's just the 2 people that are really going to be talking. When the court comes up, I will mention that. So we get on to the direct examination by Mr. Blanche. Good afternoon. Where do you work? I work for Blanche Law. You work for me. I do. You're a paralegal. I am. You've been in court. Generally speaking, what is your job? I assist attorneys in whatever comes up. A lot of it, as a defense firm, is reviewing discovery, which is evidence produced in case, summarizing it, helping with filings, research stuff, editing motions. This past Friday, so 3 days ago, after trial ended on Thursday, were you asked to do anything? Yes, I was asked to create a summary chart of phone calls. What did you do to accomplish this task? So I looked in the People's Exhibit 400 for the phone logs of Mr. Cohen's phone number ending with 0114. I looked for contacts or contact between the phone number and 3 phone numbers associated with Robert Costello. So anyone that may have appeared in the phone log, I would copy and paste certain information like the time the phone call was made, how long the phone call lasted, the date, into an Excel spreadsheet. So you created an Excel spreadsheet. Yes. I'm going to show you, the court, and the parties that I marked for identification as B101A, whereupon the exhibit is shown on the screen for the witnesses and the parties. Is this the Excel spreadsheet you created? Yes. Does it accurately reflect, with the exception of redactions, the information that you reviewed from the phone records you just described? Yes. Mr. Blanche, Your Honor, we offer B101A a summary chart. Ms. Hoffinger, no objection. The court accepted into evidence, whereas defense exhibit B110A is received in evidence. Mr. Blanche, if we can put that on the screen, looking at the top of the first page, can you just explain the call summary and walk through the headers, Mr. Cisco? Sure. So at the top, it was two participants that I called the calls for. One being Mr. Cohen and the second being Mr. Castillo. Right below his name on the right side of the page is a number that appeared in Mr. Castillo's email signature on People's Exhibit. I think it was 206 and 204. It might have the number a little wrong, but I associate it with his law firm. The first two columns on the left is call number. Just is a way of keeping track of which call in the chart we're referring to. Second is date. The third is the time that the call was made. The call logs, I adjusted that from on the call logs that appeared in UTC. I adjusted it to be a 12-hour time and also Eastern time. The fourth column is called duration. The fifth and sixth columns are to identify that correspond to the sixth and eighth columns, which is the redacted phone numbers that appeared in the call logs. I got those identities again from the exhibits that have been admitted, including numbers that appeared in Mr. Castillo's email signature. It looks like the first call, for example, the duration is 000. Is that true of a handful of the calls? Answer, yes. Do you have an understanding of what that means? That means that the call was not answered. So, if we can back this out and go to the end of the chart, whereupon the exhibit is shown on the screen, do you know how many calls there were in total, including the ones that were unanswered? 75 in total. Did you know whether there were several calls that were longer than an hour? Yes. I believe there were 6 calls that were longer than a half an hour. Mr. Blanche, if we can back this out and go to call 48, whereupon the exhibit is shown on the screens, that just means, Mr. Cisco, that the 48th call between the Castillo number and Mr. Cohen. Yes. Yeah, that's the 48th call that appeared in the call logs. The 48th call appeared on May 27th, and it appears that to last 96 minutes from Mr. Cohen to Mr. Castillo. Yes. Do you know what day that was? May 27th, 2018? May 28th was Memorial Day, so this would be Sunday before that, the day before Memorial Day, so Memorial Day weekend. And then separately, do you know what day Labor Day was in 2016? Yes. So Labor Day was September 5th in 2016. Okay. I have no further questions, Your Honor. The court, your witness. Miss Mangold. Thank you, Your Honor. Cross-examination by Miss Mangold. Good afternoon, Mr. Sitko. Good afternoon. You and I have encountered each other before, right? Yeah, we've seen each other. We worked on the same case. Yes. And you created this chart in Defense Exhibit B101A based on the underlying phone records. Yes, the People's Exhibit 400. And within People's Exhibit 400, you said you pulled the record from Mr. Cohen's phone numbers ending in 0114, right? That is correct. Those records were provided by AT&T? Yes, those AT&T records were already in evidence, but they're under seal, right? That is correct. Miss Mangold, can we pull up Exhibit E1018 for the parties on the screen? whereas the exhibit is shown on the screen. The defense team has had the record contained in People's 400 since mid-2023, right? Yes. All right. Can you please zoom into the top of the third page whereupon the exhibit is shown on the screen? Do you see the rows indicated there that it says the call is DHC? Yes. Does that correspond with the notification at the top of the chart from David Hutchinson at Citron LLP? It does. Is there a way to tell based on those phone records who at DHC was the caller? Or is that just a general firm line? It's just a general firm line. From the records, there would be no way to tell who specifically made those calls. And looking now at, I think Mr. Blanche noted that there are, can we zoom back? The number of entries in the chart where the duration is 0000? Yes, that's correct. And you said those are instances where the call was not answered, right? Yes, that is my understanding. And do you remember Mr. Blanche asked Mr. Cohen on cross, would it surprise you to learn that you actually communicated on the phone either Mr. Cohen calling or Mr. Castillo, or Mr. Castillo was calling Mr. Cohen up to 75 times? Yes. And is that 75 number based upon this chart you prepared? Yes. Now, looking at the originating number, can we zoom in at the top, maybe row 12, whereupon an exhibit is shown on the screen? Just for the record, I'll note that I believe what we've put up now might be an earlier version of the exhibit that we received without row numbers. Mr. Cisco, is that consistent with your understanding? Yes, I believe so. Okay, do you see where there's a line that says 000 DHC, that top row right from 4/16/18? Yes, just below that, almost the exact same timestamp, I believe. So the first call 000 is timestamped under 434.26, and the following call dated the same time has a timestamp at 434.27, right? Yes. This indicates that the calls were 45 seconds, right? Yes. And then on the right, there is where it has originating number. It has both the 7200 number, which is the law firm's number, main number, right? Yes. And then there's a second number below that, 3595, right? Yes. Do you know what that number indicates? My understanding is that number indicates that was forwarded to a voicemail, and that's a number associated with a voicemail inbox. So is that a voicemail that was left after the previous as part of the same call indicated above? Yes, I believe so. Okay, so there are certain calls on the chart that are double counted, right? There's first, like the one we're looking at here, the first one was a missed call that gets its own row. Then the second one is a voice call for the same call. So it's really just one call. Yeah? Yeah. And I believe your paralegal testified that these are made from how the calls bounce off the AT&T towers. Yes. That's how the records are displayed in AT&T records. Yes. But there are 75 rows on this chart, right? Yes. So all of these 75 rows, separate times that Mr. Cohen's number contacted with Mr. Castillo's number. Is your understanding there was an actual conversation, or could it be a missed call, a voicemail, or actual connection between the two? Yeah, so if Mr. Cohen and Mr. Castillo had made a push call, it could be reflected in two different lines on this for the same call. So the total number of conversations was less than 75. Conversations? Yes, certainly. Miss Mangold, I have no further questions. The court, anything further? Mr. Blanche? No redirect. The court, thank you. You can step down. Where the witness is excused, the court, your next witness, please. All right, I have to interject. So essentially, they brought up a witness who said that there was a whole bunch of phone calls, and then the prosecution came and pointed out that there are really just half of those number of calls. That was kind of an interesting play. So we continue on. Mr. Blanche, the defense calls Robert Castillo. Miss Hoffinger, we need to approach before, whereupon the following proceedings were held at sidebar. Miss Hoffinger, the general rule is extrinsic evidence by way of witness testimony is not permitted on collateral matters. My understanding is they're calling him purely on matters of credibility with respect to Mr. Cohen. The general rule is you can't admit the witness on credibility. You're stuck with the witness's answers. In an alternative, if what they're doing is saying there are some prior inconsistent statements, meaning that Mr. Castillo is going to offer 2 prior inconsistent statements by Mr. Cohen, the testimony would be limited just to those 2 statements. I say 2 statements because I've taken a look at the transcripts. I've taken a look at the transcripts, and there are only 2 questions Mr. Cohen said he didn't recall. That was the extent of it. Everything else he admitted, each and every question. And Mr. Blanche put to him with respect to Mr. Castillo. We don't think Mr. Castillo's testimony should be admitted, but if it is, should be limited only to those 2 statements. Mr. Bove, we respectfully disagree. This testimony is being offered in part to admit prior inconsistent statements through the testimony, but more importantly, it's being offered to rebuke the government's theory of a pressure campaign by President Trump in 2018. We moved prior to trial to preclude that evidence. It came in, we understand. So we're offering this as a significant part of our defense to rebuke the suggestion from Mr. Cohen that his interactions with Bob Castillo were some kind of a way for President Trump to get to him, to apply pressure. That was the general thrust of his testimony. He said that in specifics, they offered emails about this. So Mr. Castillo is going to explain his relationship with Michael Cohen from his perspective to rebuke the government's theory on this issue. Ms. Hoffinger, this is really about Michael Cohen's state of mind. That's the purpose of what you admitted it for, which is why he didn't tell the truth for a very long time. He said repeatedly he did not tell the truth to Mr. Castillo. At no time did he tell him why. So Your Honor said that the evidence would not be permitted for a conscience of guilt for Mr. Trump. What we're talking about here is Mr. Cohen's state of mind, and you ruled that was admissible for that purpose. Mr. Bove, our position, and we're seeking to bring this out through the testimony of Mr. Castillo, is that Mr. Cohen lied about his interactions with Bob Castillo, and he lied about his state of mind in this time frame, and that he very much wanted to be in touch with Rudy Giuliani, to put questions to the president, to try to extract information about the investigation. This is very much a rebuttal of what the government believed before they opened was an important part of their case. And it also goes to the credibility of the star witness. And it's admissible for all of these reasons. I understand, I would expect with any witness, we take it question by question to some extent. Generally speaking, our theory of admissibility is to rebuke this pressure campaign concept and to put into evidence that whatever is being said today about Mr. Cohen's state of mind, what he said was his state of mind in 2018 was false, because Mr. Castillo will say it's false. Ms. Hoffinger, Mr. Cohen admitted to reach out to Rudy Giuliani. What it's being admitted for is to rebuke the credibility of Mr. Cohen. It's not admissible for the purpose he's not entitled to elicit opinion, testimony about the credibility of Mr. Cohen, the court. We should have discussed this before, and I'm going to excuse the jury, whereupon the following procedures were held in court. The court, I apologize. I'll ask you to step outside for a few moments, whereupon the jurors and the alternate jurors were excused. The court again, I do wish we had discussed this earlier. People, let me hear your objection, your concerns. Miss Hoffinger, sure. Your Honor, again, to say that Mr. Castillo, it appears, is being brought in to provide extrinsic evidence to rebut a witness testimony on collateral matters. And the general rule is that you're stuck with it. You're stuck with the witness answer on those matters that affect solely credibility. To the extent that defense is offering statements by Mr. Castillo as prior inconsistent statements of Mr. Cohen, then we would say if his testimony is admitted, which we believe it should not be, if it's admitted, it needs to be limited and restricted only by those prior inconsistent statements. They're not entitled to elicit from Mr. Castillo his opinion about Mr. Cohen's credibility. They should be restricted just to the two questions, frankly, that Mr. Cohen testified that he didn't recall. All he said was that he didn't recall. He didn't recall Mr. Castillo telling him in the first meeting that he could or should cooperate against President Trump. He didn't recall. He didn't recall the word saying that he didn't. That he said, Mr. Castillo, he had nothing on the president. That he said to Mr. Castillo that he had nothing on the president. But you will recall that he testified several times that he did not tell the truth to Mr. Castillo. He absolutely did not tell the truth. He knew it would get back to Mr. Trump through Mr. Giuliani. So I think there's very little testimony that would be permissible, if at all. We move for the testimony to preclude, but if it's admitted, it should be on a very narrow basis. Mr. Bove, as I said at sidebar, this testimony to me is being offered to rebut the government's argument about a supposed pressure campaign from President Trump. And I think you just heard a little bit about it, which is that it's the government's theory. It was Michael Cohen's testimony that he was too concerned about the possibility that information that he provided to Mr. Castillo in a privileged setting would get back to the president. We opposed the offer of all that type of evidence prior to the trial. The government put it in. We provided notice days ago of our intention to put Mr. Castillo on. There's no mystery here. What we're seeking to do is to counter that evidence. I'm not going to elicit, of course, I'm not going to elicit Mr. Castillo's opinion of Mr. Cohen's credibility. I am seeking to elicit many facts about the way their engagement worked between April 2017 and the summer of, April 2018 and the summer of 2018 that bear on things that Mr. Cohen said. For example, he said, I never agreed to retain them. This issue about I was concerned that it couldn't say things because they would get back to the president. The idea that Mr. Castillo was pestering him instead of it being the other way around. All these issues we didn't bring up. We didn't think this should be admissible. They brought it up. Now we're seeking to offer evidence to respond to the argument they made in their opening and put in through Mr. Cohen. In terms of prior inconsistent statements, evidence, what I expect Mr. Castillo to say is different from what Mr. Cohen said. Mr. Castillo suggested as he sat at the Regency Hotel at this meeting with Mr. Castillo and Jeff Citron and omitted information because he was concerned if he said certain things, they would get back to the president. That's not Mr. Cassillo's recollection of the conversation at all. What Mr. Cassillo recalls is Mr. Cohen saying President Trump did not know about the statement. Excuse me, the payment to Stephanie Clifford. That's extremely prohibitive of the core issue in this case. It's not collateral at all. It's going to the heart of the government's theory. So both in terms of evidence of prior inconsistent statements that we will be offering through Mr. Cassillo, that's somewhat limited. And also, I think more importantly, to rebuke the government's pressure campaign theory, that's why this testimony is admissible. You know, I understand the objections. The court. You don't think the pressure campaign theory is collateral? Mr. Bove, not at all, Judge. They didn't ask the guy questions about this. They put in exhibits. They asked how the relationship went. The whole purpose of this was to make President Trump sound threatening, to make it sound like he was interfering with the investigation. The court, I don't think so. I think the reason for it was to explain why at one point he said one thing and at another point he said something else. That doesn't go to the element of your defense. It doesn't go to your client's guilt or innocence necessarily. It goes to the credibility of Mr. Cohen. Mr. Bove, Judge, the government is to be suggesting, they're basically suggesting that it includes through that tweet in, I believe in April 2017, that they juxtaposed against email traffic with Mr. Castillo. The government suggested to this jury that President Trump was tampering with this witness. That is their theory of what the pressure campaign was. They elicited Mr. Cohen how he felt about these things as they're going on. We, the court. How can Mr. Castillo testify as to what Mr. Cohen felt? Mr. Bove, he can't. He can testify to what Mr. Cohen said and what Mr. Cohen did. There are many, many examples at this trial where even witnesses who were not a party to the communication were allowed to offer a lay witness opinion. The court, for state of mind, yes, Mr. Bove. So, in this sense, the witness opinion is admissible with respect to Mr. Cohen's state of mind. In the same way, it's admissible with respect to any other time. The court, I disagree. Mr. Castillo can testify to Mr. Cohen's state of mind. I'll consider some of your other arguments. I disagree with that, Mr. Bove. Mr. Castillo will testify that he understood communication, what he understood communication to be. That's all I'm saying. In the same way, many other witnesses at this trial have done. Ms. Hoffinger, I think you have our point at this point. Wait, let me redo that. I think you have our point at this point. The only other piece is that rebutting the so-called pressure campaign, which, as Your Honor knows, that was not our purpose in putting this in. It was for Michael Cohen's state of mind and why he didn't tell the truth for a long time. Rebutting the pressure campaign should be part of their direct case. It's not impeachment. They didn't put the witness on their witness list as a direct witness. They didn't get, for example, exhibits that we were supposed to get. We got them recently in terms of Mr. Cohen, and they might use them with Mr. Cassillo too. We heard this morning he was coming. They let us know a couple of days ago he might. That's direct, not impeachment. The question is whether he's allowed for prior inconsistent statements. I suggest anything else, retainer agreements, whether he paid for him, or anything else that's lateral and collateral, he shouldn't be testifying to that. If it's a prior inconsistent statement, his attention should be drawn to the exact statement, and his testimony should be limited to that. Mr. Bove, part of what Mr. Castillo is going to do is explain that certain things Mr. Castillo testified about at this trial were false. Things like Mr. Cohen's testimony that there was never an agreement, even verbal, that Mr. Castillo would represent him. Things like that, where Mr. Castillo is providing direct evidence of perjury at this trial, are never collateral, Judge. That's what we're seeking to lay out. Ms. Hoffinger, it's entirely collateral, Your Honor. Mr. Bove, that he committed perjury is collateral? The court, I'm going to take 5 minutes. Don't leave this courtroom. Whereupon the court exits the courtroom and a pause is taken in the proceedings. Whereas the senior court reporter, Lisa Kaminsky, relieves senior Lori Eisenberg, and the transcript continues as follows. I hope you all kept up with that because we were jumping around. All right. The following proceedings contained from the proceedings page, whereupon the court resumes and the bench in the proceeding. The court. So, Mr. Bove, you can definitely cross-examine as to the two prior inconsistent statements, obviously. But I will give you some latitude to explore the pressure campaign so that you can elicit some inconsistencies. So you can offer some rebuttal of Mr. Cohen's testimony. But I'm not going to allow this to become a trial within a trial as to whether or not there was, in fact, this pressure campaign and how it affected Cohen. That's not the purpose of this trial, and I don't want it to become that. As far as the retainer issue, that's collateral. We don't need to go into that at all. Okay. All right. Let's get the jury, please. Mr. Bove, should we get the witness first, Judge? The court, no. The witness is yet to be sworn in. The court officer, all rise. Jury entering. Court, you may be seated. Clerk, case on the trial continues. All members of the jury are present and properly seated. The court, counsel, please call your next witness. Mr. Bove, the defense calls Robert Castillo. The court officer, ready for the witness, Your Honor. The court, yes. The court officer, witness entering. The witness, Robert J. Castillo, enters the courtroom and steps up to the witness stand. The court officer, watch your step. Witness, thank you. Court officer, remain standing. Raise your right hand and face the clerk. Robert J. Castillo, a witness called on behalf of the people, having been first duly sworn, was examined and testified as follows. The clerk, thank you. The court officer, have a seat, please. The witness, thank you. The court officer, state your full name, spelling your last name. Witness, Robert Castillo. That's awfully loud, Robert Castillo. The court officer, spell your last name. Witness, Costello. The court officer, please give your country of residence. Witness, country of residence is Nassau County. The court, you may inquire. Mr. Bove, thank you, Judge. Direct examination between Mr. Bove and Robert Castillo. Again, I'm just going to kind of read. I'm not going to go and put Q&A and all that. And just try to let this conversation flow. The last section was really a lot going on there. So, by Mr. Bove, direct examination by Mr. Bove. Good afternoon, Mr. Castillo. Good afternoon. Where do you work? I'm sorry, where do you work? Oh, I'm a partner in a law firm of David Hutchison and Citron. How long have you been at that firm? About 7 years. And prior to your work at the law firm, did you have some government service? I did. When? Approximately, that was 1975 to 1982. And describe your service for the jury, please. I was an assistant U.S. State's Attorney in the Southern District of New York, right down the block. I was in 81 and 82. I was a deputy chief of the criminal division there. And so you were a federal prosecutor in Manhattan, right? Yes, I was. Do you know somebody named Michael Cohen? I do. When approximately did you meet Michael Cohen? I met him exactly April 17th, 2018. Did you meet with him in person that day? I did. Where was the meeting? It was at the Regency Hotel in Manhattan. And I was accompanied by Jeff Citron, one of my law partners who knew Mr. Cohen. Now, did you consider your conversation at the Regency Hotel that day to be a subject of the client-attorney privilege? The court, sustained? Absolutely. Ms. Hofflinger, objection. Court, sustained. Mr. Hoffinger, can that answer be stricken? The court, and the answer is stricken. Who was at the meeting of the Regency Hotel? Michael Cohen, Jeffrey Citron, and myself. Did the topic of a potential cooperation come up? Yes, it did. What was discussed? Well, first Michael Cohen explained the situation because I had never met Cohen before, so I had no idea what was going on, and that his name and his law office had been searched pursuant to a search warrant, and he was absolutely manic about the beginning and throughout the 2 hours that we were meeting, marching back and forth, pacing. We were in the conference room of the second floor of the Regency Hotel, and he kept pacing back and forth, left and right, while myself and Jeff were seated. And after he explained what was going on, he said, "My life is shattered. My family is shattered. I don't know what's going on." He said, "I really want to explain to me what my options are. What's my escape route?" That's the phrase he used. So, was cooperation one of the options you were described in response to the question? Absolutely it was. What did you tell Mr. Cohen that day? I explained to Mr. Cohen that he described the search warrants. I pointed out that a search warrant of law office is much more difficult to get than a search warrant of any other place. Mr. Hofflinger, objection. Court, sustained. What was your view that day about whether or not Michael Cohen should cooperate? Ms. Hofflinger, objection. Court, sustained. What instruction did you give Mr. Cohen with respect to cooperation? Okay, I explained to Mr. Cohen that it was obvious that he was not the target of the search by the Southern District of New York, that they thought he had committed some crimes. Ms. Hofflinger, objection. The court, sustained. I just want to stay narrow on the topic of conversation and the instructions that you were given, that you gave Michael Cohen. Okay. I explained to Michael Cohen that this entire legal problem that he was facing would be resolved by the end of the week if he had truthful information on Donald Trump and cooperated with the Southern District of New York. And what, if anything, did Michael Cohen say about President Trump at that point in the meeting? He made the same statement that he made 10 or 12 times that day, quote, "I swear to God, Bob, I don't have anything on Donald Trump." Did the topic of Stormy Daniels come up? It did. What, if anything, did Cohen say about Stormy Daniels during the meeting? Ms. Hoffinger, objection, Your Honor. The court overruled. You can answer. Answer. He began saying, "I don't understand why they're trying to put me in jail for some effing NDAs, which is a non-disclosure agreement." He then said, "I did an NDA with Stormy Daniels." So I asked him to tell me about the circumstances and how was he involved. Mr. Hoffinger, objection, Your Honor. The court, sustained. Mr. Hoffinger, can you strike the answer? The court, the last answer is stricken. Yes. Question, did Mr. Cohen say anything about President Trump in connection with the Stormy Daniels part of the conversation? He did. Ms. Hoffinger, objection, Your Honor. The court, sustained. Mr. Bove, may I be heard, Judge? Court, no. Please continue. Did President Trump's family come up? Yes, it did. What did Mr. Cohen say about President Trump's family? Ms. Hoffinger, objection, Your Honor. The court, sustained. Please approach. Sidebar. Ms. Hoffinger, Ms. Steinglass would like to be heard. Ms. Steinglass, thank you. Respectfully, this is exactly what you just told him not to do. if he's going to be impeaching Mr. Cohen by prior inconsistent statements, the law is extraordinarily clear on this. The witness's attention has to be specifically called to the prior inconsistency, and he has to be given a chance to explain it. Only if he maintains the inconsistency or he says he doesn't remember is impeachment by a prior inconsistent statement by a collateral witness permitted. There were two inconsistencies where that happened. One, Mr. Bove just covered. We're going way far afield of that. This is not a general, everything Mr. Cohen testified. Did he tell you something different? Did he tell you something different? Did he tell you something different? He would have to confront Mr. Cohen with those inconsistencies and say, didn't you tell Mr. Castillo X, Y, and Z on this date? And then Mr. Cohen would have to have denied it. And then it would be permissible. It is not permissible to have a wholesale everything that Mr. Cohen said. Mr. Bove, that's not what I'm trying to do, Judge. I'm trying to get to a specific statement that Mr. Cohen had made that President Trump did not know about, one of the payments to Stormy Daniels, which is not the court. Well, why don't you just get to that, Mr. Bove? I'm trying, the court. Because right now, what's happening is you're asking these questions and he's going off and he's telling the story. I am going to sustain the story. And I'm going to sustain the story. Mr. Bove, may I lead him then? May I lead the court? Just get to the question that you want to ask. Ms. Hoffinger, one question. You have one question. You've already gotten two. There's only one more. The court, that is it. Sidebar concluded. Continue direct examination by Mr. Bove. Mr. Castillo, we are still focused on April 17th, 2018, meeting at the Regency. And I want to focus very narrowly on whether Cohen said anything about President Trump knew about the payments to Stormy Daniels. Answer, yes. What did he say about the specific topic? Michael Cohen said numerous times that President Trump knew nothing about the payments, that he did this on his own, and he repeated that numerous times. Was Rudy Giuliani discussed at this meeting? Mr. Hoffinger, objection. The court, I will allow it. You can name he came up very briefly. Just in the fact that I had been a student assistant back in the early 70s. Other than that, we didn't discuss him. Mr. Bove, I would like to bring up Mr. Burnick, Government Exhibit 203 in evidence. If you can zoom in on the email, please, displayed. Do you see the same email? I do. And is this email that you sent Mr. Cohen 2 days after the meeting on April 19th? That is correct. Why did you send an email to him? Because it was announced that day in the newspaper and on TV that Rudy Giuliani was joining Donald Trump's legal team. Mr. Bove, and if we can take a look now at the contents around the email by bringing up Exhibit B1003 in evidence displayed. And let's start by zooming in on the 6:45 p.m. email. Right, I see it displayed. Now, that's the same email we were just looking at, correct? It is, yeah. And now let's look at Mr. Cohen's response at 7:36 p.m. displayed. Do you see where Mr. Cohen wrote back to you? Have great news for Rudy. Yeah? What did you understand him to mean? Ms. Hoffinger, objection. The court sustained. Do you see where Mr. Cohen wrote, I've been working with lawyers all day? Correct. What did you understand him to mean? Mr. Hoffinger, objection. The court overruled. You can answer. He was working with McDermott, Will, and Emery, a Washington law firm, and they were going over the evidence that had been seized pursuant to the search warrants, and presumably they were selecting documents that might be claimed to be attorney-client privilege or work product privilege. Did Mr. Cohen ever say anything to you about not being able to retain you because he had retained McDermott firm? Ms. Hoffman, objection, Your Honor. Court sustained. Not directly. He complained. The court sustained. Ms. Hoffman, objection, Your Honor. Court sustained. Ms. Hoffman, can the answer be stricken from the record, Your Honor? The answer has been stricken from the record. When I sustain objection, you don't need to answer it. Did there come a time when there was a conversation about retaining you between you and Cohen? Sure, many times. I would like to focus on the period around April 19th, 20th of 2018. Do you remember a conversation about retention? Ms. Hoffinger, objection, Judge. Not off the top of my head. Well, what do you recall about the general topic? Objection, Your Honor. Court sustained. The issue was that objection, Your Honor. Court sustained. Witness, I'm sorry. Ms. Hoffinger, we moved to strike it. The answer is stricken. Mr. Bove, now, if we could take a look at the Government Exhibit 204 in evidence, please. Mr. Bove, if we can zoom in on the email and the header, please. Right, I can see that. Now, this is a message that you sent Michael Cohen on April 21st, right? That's correct. And do you see the subject line? It says Giuliani. Yeah, Giuliani, right. And the message you wrote, I just spoke to Rudy Giuliani and told him I was on your team. Yes, I did. And Cohen instructed you to do that. He did. Do you see at the end of the email where it says, he said, thank you for opening this back channel of communication and asked me to keep in touch? Yes. Is that term back channel, is that a term that Mr. Giuliani used? Yes. Objection. Court sustained. Ms. Hoffinger, moved to strike, Your Honor. The court stricken. What had Michael Cohen said to you about how to communicate with Rudy Giuliani? He told me that I was authorized to tell Giuliani that my firm was, quote, on the team. That's a phrase that he used. But that he was going to announce it publicly so that although I could tell Giuliani and Giuliani could tell anybody else associated with the president, he wasn't supposed to tell the media. And that's why he used the term back channel. And there sometimes when Ms. Howard, objection, Your Honor, court overruled. Were there some times when Michael Cohen instructed you to ask questions of Rudy Giuliani? Correct. What types of questions? He wanted to know how the investigation of Michael Cohen began. He wanted to know whether it was a referral from Washington. How did it get to the Southern District of New York, which is the federal court right down to the street here. And he wanted me to ask Giuliani if Giuliani knew. So Cohen was trying to get information from Rudy Giuliani. That's correct. Mr. Bove, now if you could take a look at Defense Exhibit 1006 in evidence, please. Can we zoom to the header email? Thank you. So this is an email that you sent to Michael Cohen on April 23rd, 2018. Do you see it? Yes, it was. I do see it. And do you see the subject line, assignment? Where you're reporting back on an assignment from Michael Cohen. Yes, what he asked me to do, right. And the email began, I spoke with the person you asked me to. Do you see that? Correct. Who were you referring to? Rudy Giuliani. And then it continues. He said that he would find out exactly how the matter ended up in SDNY, and in particular, who in Main Justice approved it. Did you see that? I do. And is that something that Rudy Giuliani said to you in response to Michael Cohen's question? It is. And is that something that Rudy Giuliani... Oh, it is. I would like you to take a look at the second paragraph of that email. Do you see where it says the question of timing is premature? Yeah, I see that. What did you mean by that? Ms. Hoffinger, objection. Court sustained. Answer. Jeez. Was that a response to something Michael Cohen had instructed you to do? Ms. Hoffinger, objection. Court sustained. Yes. Strike it. The court. Counsel. Let's take a minute. Can the jury please step out? Court officer, all rise. Jury. The court. Mr. Casilla, you remain seated, please. Remain seated. You may be seated. Mr. Casilla, I would like to discuss proper decorum in my courtroom. The witness, but I'm sorry. Go ahead. The court, I want to discuss proper decorum in my courtroom. The witness, right. The court, okay. So when there is a witness on the stand, if you don't like my ruling, you don't say geez, okay? And then you don't say strike it, because I'm the only one who can strike testimony in the courtroom. Do you understand that? The witness, I understand. A court, okay. Then if you don't like my ruling, you don't give me side eye, and you don't roll your eyes. Do you understand that? Do you understand that? The witness, I understand that. I understand what you're saying. The court, okay, thank you. Let's get the jury back. Are you staring me down right now? The witness, no, I was just wondering how. The court, clear the courtroom, please. Clear the courtroom. The witness, do you want me to answer your question? The sergeant, please. The court officer, step outside, please. Step out. Step to the side, please. Step out, please. Quiet, please. Step out. A person in the audience, Your Honor, may I object on behalf of the press? Your Honor, your lawyer is objecting. The press lawyer is objecting. We have a right to remain here. The court officer, step out, step out. A person in the audience, why? This is an open courtroom. Court officer, step out. Any questions? Any at all? Any and all questions will be answered in the hallway. A person in the audience, the press lawyer has a question. The court officer, this is not an open forum. You will answer all questions. We will answer all questions in the hallway. Step out, please. This is a Supreme Court courtroom. Step out. A person in the audience, this is an open courtroom. A person in the audience, it is open to the people, open to the public. You can't throw us out. A person in the audience, our lawyer has a question. This is a public forum. Why do we need to step out? The court officer, step out, please. Person in the audience, where do you want us to go? We have a lawyer here. A person in the audience, I'm a lawyer. The court officer, keep going, please. I will answer all questions out in the hallway. I will answer everything in the hallway. But right now, everybody step out. A person in the audience, we are guests. Why do we have to leave? Court officer, step out. Everybody step out into the hallway. Let's go. Person in the audience, will this be on the record so we can read it afterwards? Court officer, step out, please. Step out. Step out, please. Step out. The court is clear of people in the audience by the court officer at this time. The court, all right. Let the record reflect that it's now 5 after 4. Let the record also reflect the court officer had great difficulty clearing the courtroom because the courtroom is made up primarily of press. And I can appreciate that the press wants to be present for every part of the proceeding. Therefore, this record is not sealed. The press will have access to this record. The fact that I had to clear the courtroom and that the court officers, including the captain, had great difficulty clearing the courtroom, and that there was argument back and forth between the press and including counsel for the press, goes to why I had to clear the courtroom in the first place. And that is, sir, your conduct is contemptuous right now. I'm putting you on notice that your conduct is contemptuous. If you try to stare me down one more time, I will remove you from the stand. I will strike your entire testimony. Do you understand me? Mr. Bove, yes, Judge, I understand. The court, listen to the question and answer The question, the witness, can I say something, please? The court, no. No, this is not a conversation. The witness, okay. The court, all right. We can bring the press back in, please. Court officer, ready, Your Honor. Court, yes, please. The court officer, okay. The press is entering the courtroom. The people in the audience return to the courtroom. The court officer, same seats, folks. Same seat, same seat, same seat. The court, let's get the jury, please. The court officer, juror entering. All rise. Jury enters. The witness, you don't want me to rise? Court officer, no. You may be seated. The clerk, case on trial continued. All jurors are present and properly seated. The court, Mr. Bove. Mr. Bove, thank you, Judge. Continued cross-examination by Mr. Bove. Mr. Bove, may I inquire? The court, yes. Mr. Bove, Mr. Burnick, if you could please bring up defense 1008 in evidence and zoom in on the bottom email. Mr. Castillo, this is a message from you to Michael Cohen. Do you see that in the top left? Yes. It's yes. In the right, and the date is May 16th, 2018. Right. May 16th. You wrote at the bottom of this message, I will not pester you. If you want to talk, you know how to reach me, Jeff. How to reach Jeff or myself. Do you see that? I do. Is Jeff Mr. Centron that you had mentioned earlier? That's correct. And what were you trying to convey here? Ms. Hoffinger, objection, Your Honor. Whoops. Had a mishap with the camera. We got pause here. Sorry about that. I have a bird here in the studio and he messed with my camera. So we'll pick it up. Answer. Michael had been complaining about the lawyers. He was complaining about Steve. Ms. Hoffinger, objection, Your Honor. The court sustained. Ms. Hoffinger, we moved to strike. The court, the answer is stricken. What do you mean, not to pester? Meaning he would not hear from me again unless he contacted me. Mr. Bove, if we could keep this on the left side of the screen and bring up the phone record chart. Defense Exhibit 1018, please, displayed. Mr. Bove, if we could zoom in on rows 47, 48. So we were just speaking about an email on May 16th of 2018, right? Correct. And the next call on the chart is this Sunday, Memorial Day weekend, right? That's right. And who called you? Michael Cohen called me. How long was that call? An hour and 36 minutes and 15 seconds. Did Michael Cohen give you instructions during the call without getting into what the instructions were? Yes. And I understand there is a waiver. We were just trying to keep this narrow. So he gave you some instructions and discussed legal issues during the call. Yes, I did. Mr. Bove, if we could take a look at the Government Exhibit 206 in evidence, please. Displayed. Mr. Bove, if we can zoom in on the header and email. In this email, you sent Mr. Cohen on June 7th, 2018. Do you see that? I do. And from the text in the email, it looks like there had been some conversations between Mr. Cohen about Giuliani. Correct? That is correct. Mr. Bove, now I would like to take a look at the phone record chart again. So if we keep this on the left and put up the defense on 1018, the right again. If we can zoom in on rows 50 to 56, please. So does this part of the chart, defense B1018, reflect a series of calls between you and Mr. Cohen on this same day as this email? Yes, it does. And do you see in row 57, the call lasted 46 minutes and some change? I do. Who initiated this call? Mr. Cohen. And during those calls on June 7th, did Mr. Cohen instruct you to contact Mr. Giuliani? Pause. You could take a look at the second paragraph of the email on the left. It says, after you called me back at 2:43 p.m., We spoke, and I called and left a message for Rudy. Yes. Does that refresh your recollection as to whether or not you got instructions that day about calling Mr. Cohen from Mr. Cohen? Yes. Now, if we could make a phone chart, Defense B10018, the main exhibit, zoom in on rows 57 through 64. And does this part of the chart reflect a series of calls on June 12th and the last one on June 13th, 2018? This is correct. If we could bring up now June 13th email, which is government 207 and evidence is displayed. And I just want to zoom in on the last paragraph of the message. It's on the second page. This is a message that you sent to Mr. Cohen on June 13th. Do you see where you wrote, please remember, if you want or need to communicate something, please let me know. I will see that it gets done. Right. And you were communicating to Mr. Cohen there. Ms. Hoffinger, objection, the court overruled, you can answer. Mr. Cohen was making constant complaints about Rudy Giuliani and what he was saying to the press. And he was also complaining that his law firm, McDermott, Will, and Emery, Ms. Hoffinger, objection, the court sustained, hadn't been court sustained. Again, please just answer the question. Witness, okay. Mr. Bove, now if we could take a look at Government Exhibit 208, which is in evidence. And if we can zoom in on the header and email. This is a message that you sent to Michael Cohen that next day, June 14th, correct? Correct. Mr. Bove, I would like you to focus on page 2 of this. And if you could zoom in on the top paragraph that carries over. Do you see where you wrote, if you really want certain things to happen, you should make them known. You should make that known. If you really want other lawyers to refrain from saying this or that, you should make it known. Do you see that? I do. And just very, very narrowly, with respect to those two sentences, what were you communicating to Michael Cohen on June 14th, 2018? That was in response to his complaint. And I said, if you want to let anybody know what you are complaining about, just tell me and I will pass it on. And who were you telling Michael Cohen you would pass it to? He, Rudy Giuliani. Mr. Castillo, did you ever put any pressure on Michael Cohen to do anything? No. Did you ever pressure him to interact with Rudy Giuliani in a certain way? Not at all. Did Mr. Giuliani ever put pressure on you to try to extract information from Mr. Cohen? Mr. Hoffinger, objection, court sustained. Did you ever perceive of any type of pressure from Rudy? Ms. Objection, court sustained. Move to strike. Answer, no. Ms. Hoffinger, move to strike, Your Honor. Court, it is stricken. During your interaction with Mr. Cohen, did you consider him a client? Absolutely. I had to treat him that way. And those interests did you have in mind during the course of your relationship? Exclusively Michael Cohen's. Did you care about President Trump's interests while you were dealing with Michael Cohen? No, my obligation was to Michael Cohen. And at some point, did your firm seek payment from Michael Cohen? Yes, they did. And did he pay? No, he did not. Were you aware of that the firm was trying to collect on that? I'm sorry, I couldn't hear you. Were you aware of efforts by your firm to collect payment? No, they didn't sue. It wasn't enough. The amount wasn't enough. Now, before I sit down, we met before, right? Yes. And you've also had meetings with state and federal prosecutors regarding Michael Cohen, right? Oh, yeah. And did you turn over documents during those meetings? I did. A lot of documents. And answer questions from both state and federal prosecutors at different times, yes? And more recently, have you appeared in the media in conversations on this case? Yes? Fair to say frequently, yeah. And have you testified in Congress about this case? I did, the House Judiciary Committee. And that was actually while this trial was ongoing, right? I think it was. It was last Wednesday. Mr. Bove, nothing further, Judge. Court, your witness. Miss Hoffinger, thank you, Your Honor. Cross-examination by Miss Hoffinger. All right. I'm listening, I'm reading this, and I'm trying to process this as I'm reading it. I don't see the point of why they brought this man up there. To be honest, I don't see how that is a defense. It's a defense to what? I don't understand where he was going with that. So anyway, we can go into the cross-examination. Good afternoon, Mr. Castillo. Hi. On April 17th, 2018, your partner, Joe Citron, reached out to Michael Cohen by email. Is that correct? Yes. Jeff Citron, I apologize. Jeff Citron? Answer, yes. To see if he would be interested in meeting with you. Is that correct? I'm sorry. Say that again. To see if Michael Cohen would be interested in meeting with you. Is that correct? No. The email speaks for itself. Well, let's take a look at People's Exhibit 512P well before we put it up. Mr. Citron did not email Mr. Cohen to see if he wanted to meet with you. He did. Yes, he did. And didn't Mr. Citron in that email lay out all of your qualifications, that you are a former chief of the criminal division of the U.S. Attorney's Office, and that you had represented famous people like Leona Hensley and George Steinberg? Didn't he send that type of email to Mr. Cohen? I don't remember. The email speaks for itself. Well, let's take a look at that. Ms. Hoffinger, let's look at the People's Exhibit 512P, just for the witness in the court counsel, and display the aforementioned parties. Do you recognize that email, sir? Yes, I do. Who is that email from, and to who is copied on that? Well, that was from Jeffrey Citron to, it's blacked out, but this should have been Jeffrey Citron to Michael Cohen. And are you copied on that email, sir? I'm sorry. Are you also copied on that email? Witness reading. I know there are certain redactions, but does it appear, what's confusing to see is this is saying it's from Michael Cohen to Jeffrey Citron, but I guess this is a string. It's a string, so look at the bottom. So I'm having trouble seeing the string, yes. So you were on those emails. Yes, I was. I offer those in evidence, Mr. Bove, no objection. I accept it into evidence. So now you see an email that Mr. Cohen sent and copied you on. Are you aware of that now? Do you see the email exchange? Extolling your experiences, your family, your famous clients, and what you wanted. Except you misstated it before. You stated it was chief of the criminal division. It's deputy chief. I apologize for that. Deputy chief of the criminal division. Is that otherwise accurate, the question I ask you? It is, yes. Question. And you were hoping Michael Cohen would hire you as his lawyer, correct? I wasn't hoping anything. It wasn't my email. I'm sorry. You heard about the case in the news, sir. And Michael Cohen had search warrants in early April of 2018 as the personal attorney to President Trump. Had you heard about it in the news? I probably did, yeah. It was big news, right? If you heard about it, I guess it was. If I heard about it, I guess it was. And your partner thought it would be a good opportunity to see if you could get Michael Cohen as your client, isn't it? No. This is Jeffrey Citron's relationship with Michael Cohen. He knew him for 10 years. I didn't know Michael Cohen from a hole in the wall. So you weren't interested in having him as your client? No, I wasn't. And so you met with him, but you weren't interested in retaining him. Is that right? I met with him because Jeff Citron made arrangements with Michael Cohen, and he asked me to come along because Jeff Citron is a real estate attorney, and this was obviously a criminal matter. So you were just accompanying him to the meeting. Well, I wouldn't say I was just accompanying him. It was Jeff Citron's client, not mine. But I thought you said you knew each other. He wasn't his client, I thought you said you knew each other. Yes, Jeff Citron knew Michael Cohen for at least 10 years. So you knew at the time, based on the news, that Michael Cohen was President Trump's personal attorney, correct? I think I knew that before we entered the Regency Hotel, yes. And if you could land him as a client, personal attorney to the president, that would be a big case for your firm, wouldn't it? I suppose so. And it would get you public exposure, wouldn't it? Yes, it would. And you would be in the news as his attorney, right? I guess that's true. And this is what you would call a high-profile case for you, right? Probably yes. And it would connect you with the President of the United States, right? Because he was his personal attorney, right? No, it would not. It wouldn't connect you with the President of the United States and those who were close to him, like Rudy Giuliani? No, Rudy Giuliani wasn't involved in representing President Trump at that point in time. He wasn't in the picture at all. But just a few days later, he was representing the President Trump, right? 2 days later is not the date that we met him, yes. So it was your testimony that this wouldn't push you into the arena with Rudy Giuliani and the President and President Trump by representing Michael Cohen. I don't understand the question. What do you mean it would push me into the arena? Well, I will withdraw the questions. Having Michael Cohen as a client, you said would be a big win for you and your firm, correct? I didn't say that. You did. You did. I'm asking you, would it be a big win for you and your firm? No, I wouldn't say so. I didn't want him as a client with the firm. Would it be something that you would announce on your website, your firm's website, if you had him on the client list as your client? I don't know what the firm would do. Question. Okay. Ms. Hofflinger, can we please show people's 528M just to the witness, please, the court and the parties? Display the format and parties, and maybe you can review this email and let us know who it's from and who it's to. Yes, I have to read it. I know what it is. Who is it from and who is it to? This is from me to my son. What's the date of this email, sir? April 20th. I offer that into evidence. Mr. Bove, no objection. Accepted into evidence. Can we put that up on the screen, please? I would like to ask you to please read it. Please read your email to your son and your son's response, if you would. You want me to read it? Yes, sir. If you're able to. Okay. From the bottom up, it says, I will be on the team that was Michael Cohen's phraseology. Quote, it would be an honor to have you as part of my team. I will be eternally grateful for the help and guidance you have already given me. That's a quote from Michael Cohen. If you would just read the email, please, from your son. That's what it says. It says it's in quotes, and it says Michael Cohen's personal attorney to Donald J. Trump. I did read it. Okay. The second paragraph. This is not public. That too was from Michael Cohen. Yet, so do not say anything to anyone about this. I do not know when he will make the announcement, but I have been authorized to contact Rudy Giuliani as counsel to President Trump and tell him that I will be representing Michael Cohen. That's my Michael Cohen instruction, right? Question. So what you're saying is you were not saying that you're going to put it on the firm's website. You were not going to announce it. Is that right? This has nothing to do with my firm's website. It says, I don't know when it's going to be announced. Please keep it to yourself. Answer, announced by Michael Cohen. So what are you saying? So what you're saying is that that's all Michael Cohen's language, not you telling your son, right? Okay, yes. Okay, can you read your son's response? Wow, that's big news. Congrats, Dad. I hope this leads to a lot of good things coming your way. That's from my son, yeah. And so you were telling your son that you were going to be involved in this big case, and it was going to be great big news for you and your firm. Is that right? No, I was telling my son exactly what I told you in this email. And this is his response to it. Okay, now let's talk a little bit about the meeting of the Regency on April 16th, 2016. Mr. Cohen agreed to meet with you and Mr. Citron, correct? Yeah, on April 17th. Mr. Cohen Mr. Cohen requested to meet with us. He asked us to come to the Regency Hotel. Sure. After your partner, as we saw in the email, reached out to him and asked if he would like to meet with you. Isn't that right? No, that's not what he said. He said, Michael Cohen, I have a partner who used to be a deputy chief of the criminal division of the U.S. Attorney's Office. If you want to pick his brain, let me know. And Michael Cohen responded, immediately, yes, I want to meet him. So Mr. Citron reached out to see if Mr. Cohen would want to speak to you, and you had a meeting with him. Is that right? Yes. That's what the email said. Okay, so let's talk about that meeting on April 17th. Sure. Now you said that you met with him at the Regency Hotel where he was staying with his family, correct? We met with him at the Regency Hotel. I didn't know where he was staying. He was staying there, where he was staying when I met with him. And you knew, based upon the news and the search warrants, that Mr. Cohen had been through a traumatic event, right? Yeah, I would say, sure. And because 8 days earlier, the FBI raided his apartment, his hotel room, and his office, right? I wouldn't use the term raided. They executed a search warrant. And you know from your experience that executing search warrants is that they come into your place, wherever it is, and they take your personal items, phones, your devices, documents, etc. You know where the search warrant is. Do you not? Of course I do. Oh, sorry. You know what a search warrant is. Of course I do. And you know, as a result of that, you knew, obviously, he was under criminal investigation by the Southern District of New York, right? I did, yes. And that's pretty serious, isn't it? Generally, yes. And in fact, having a search warrant executed at a lawyer's office and hotel rooms, etc., that's pretty serious, isn't it? It's very serious. And it requires special proof. And in fact, you said that, well withdrawn, Mr. Cohen was visibly shaken up that day, wasn't he? He was suicidal that day, acting manic. He was manic. And you said he was pacing back and forth, right? That's correct. And you had been a criminal defense attorney for how long, sir, at this time? Oh, 40, 50 years. Now, in all that time, as a critical defense attorney, you can understand how traumatic it is for someone to go through that kind of experience. Talking to the microphone, please. Oh, sorry. As a criminal defense attorney for all of those years, you can understand how traumatic it is for someone to go through that kind of experience, right? Yeah, sure. And as a criminal defense attorney, you can empathize with someone who has gone through that experience. Can you not, sir? Yes. But you thought he was being a drama queen, didn't you? No, I didn't know Michael Cohen. I never met him before in my life. And he was putting on quite a show. And I didn't know when he initially said, sir. Question, sir, I'm answering your question. Mr. Bove, the witness needs to be allowed to finish his answer, court, surely. And he finished his answer. Continuing, he is putting on quite a show. And he explained to us, he told us that 2 nights before, he was on the roof of the Regency Hotel and he was going to jump off and kill himself because he couldn't handle the pressure of what he was sure was an ongoing criminal case coming his way. Sure. And you remember testifying in the grand jury in this case, sir? Yes, I do. And you remember that it was in March or March 20th of 2023, approximately, yeah. And did you tell the grand jury that you didn't know whether he was being a drama queen or not? Yeah, that's because, did you tell, that's because, Ms. Hofflinger, well, I'm asking the witness to answer the question, Your Honor. The court, sir, if you're able to answer the question, yes or no, please answer yes or no. If you're not able to, just let Ms. Hofflinger know and she will rephrase it. Do you want me to answer the question, yes or no? Sure. Did you tell the grand jury he was acting like a drama queen? No. I said I didn't know whether he was acting as a drama queen, right? Well, you didn't. Well, you don't like drama queens, right? I just didn't know because I didn't know the guy. I couldn't assess whether these actions by him were genuine or not. But my partner thought they were, and he knew him for 10 years. So Michael Cohen ultimately chose a different lawyer to represent him, right? Not you. Is that correct? Well, he was one of the lawyers at the time that was talking to him was McDermott, Will, and Emery. He was also talking to Guy Pietro, who he later on in June, whatever the date was, he announced publicly that he was going to retain Guy Petrello. Sorry, I said the name wrong earlier. He retained Guy Petrello instead of you. Is that correct? Retain? You mean he signed a retainer agreement? I don't know. Well, he signed a retainer agreement. Whether he signed a retainer agreement or not, he ended up going with Guy Petrello to represent him in connection with the matter in the Southern District, not you, correct? Yes, that is correct. The court, counsel, please approach. Ms. Hoffler, sure. Sidebar. The court, so I haven't asked the jurors if they can work late. Yes. How much more do you have? Ms. Hoffler, I probably have maybe half an hour at the most. But the court, let's come back tomorrow. Ms. Hoffinger, okay. Thank you. Inside the jurors, we're going to stop at this time. Before I excuse you, I remind you, please do not talk either among yourselves or with anyone about anything related to the case. Please continue to keep an open mind. Do not form an expressed opinion about the defendant's guilt or innocence until all the evidence is in. And I have given you my final instructions on the law, and I have directed you to begin your deliberations. Do not request, accept, agree, or accept or discuss with any person the receipt or acceptance of any payment or benefit in return for supplying information concerning the trial. Report directly to me any incident within your knowledge involving an attempt by any person improperly to influence you or any member of the jury. Do not visit or view any of the locations discussed in the testimony, and do not use any program or electronic devices to search for or view locations discussed in this testimony. Do not read, view, or listen to any accounts or discussions of the case. That includes the reading or listening or the readings of any transcripts of the trial or the reading of any piece on the court site. Do not attempt to do research, any fact, issue, or law related to the case. Do not communicate with anyone about the case by any means, including by telephone, text message, email, and then on. All rise. Good night. So we'll just got to leave it there. What's happening it's a lot of proceeding. But I will gonna go back and cover this because this is where this document kind of went kind of spacey. Because proceedings, Mr. Blanche, Your Honor, we do not have this now, but we conclude the people's case at the sidebar and said we're going to move the trial order of dismissal. I do not have to do that now. The court, we can do it now. That's fine. Mr. Blanche, thank you, Your Honor. Your Honor, for several reasons, we believe that the court should enter a trial order of dismissal now. First, there's absolutely no evidence that the filings were false. The business records were not false. There's no dispute that Mr. Cohen provided legal services to President Trump in 2017. Not only did Mr. Cohen admit that, but Ms. Teratoff, when she booked the records that are part of at least 12 of the counts says the same thing. When they were entered into the Trump system, they were entered as legal expenses for retainer agreement. There's no dispute that during 2017, that's exactly what Mr. Cohen was doing for President Trump. Now, not only that, but when the invoices were sent to the Trump organization, there's no evidence that those were mishandled or entered falsely. So when the invoices were sent, President Trump is not in New York. He is in the White House. And the invoices come in for services rendered. And Mr. Cohen testified that he was rendering services for President Trump during that time, as his personal attorney. So at the start, there's absolutely no false business filings. They've been accurate business filings. Second, there's no evidence that there is any intent to defraud by President Trump in connection with these filings. So even if there was evidence that the records themselves were false, but they weren't. These are records that are generated in connection with Michael Cohen's personal relationship and personal attorney-client relationship with President Trump in 2017. He was paid first by the trust for 3 of the months, and then out of the personal funds, the personal bank account of President Trump, while President Trump was the only person that had signatory authority over the bank account. So again, the idea that there would be any sort of intent to defraud by President Trump when the invoices are going to the Trump organization, a check is being generated for him to sign in the White House for the president to sign in the White House, and then which he signs in the White House. There's no evidence that there's any idea or any intent by President Trump at this time to mislead or hide or to falsify business records. And again, now these are records in his personal records of the Trump organization. So again, if there was intent to defraud, there would be evidence of something beside what we have here. Either the records are entered in a different manner, either they were entered in a false manner describing services that are different than what was actually rendered, or something to give even a little bit of evidence that there is an intent to defraud. We have none of that. And third, Your Honor, the other crimes that purportedly are being covered up in connection with these false business filings, there's no other crimes. And now the people rested earlier today, and there's no evidence, zero evidence, that anyone was thinking about a campaign finance charge in 2016 when this payment was made to Ms. Daniels. There's also no evidence that anybody was thinking about campaign finance charge when Ms. Weisselberg and Mr. Cohen met January 20th of 2017 to come up with a way that he could be paid. There is a $35,000 monthly retainer. It was established months after the election. And so there is simply no evidence that there is any effort to conceal anything, not by the president, not by President Trump, but also by the others involved. And so prosecutors have talked in their opening statement and in papers about some sort of conspiracy to influence the election. But as the court knows, there has been something, there has to be something illegal about this effort. There has to be something illegal about the efforts by the co-conspirators to influence the election. And what the evidence shows is that they've all got together in 2015 and agreed that they would talk about the positive and negative stories, and that there would be positive stories pushed, negative stories pushed, that Mr. Pecker would keep an eye on. Keep an eye out for anything that he heard that was bad about the president, about President Trump. Now, there's no evidence from any witness who testified of any criminal intent with respect to any of those of that kind. The underlying criminal intent with the people are suggested FECA, New York State, Texas tax fraud, and some others. Business record fraud that they claim showed some sort of criminal intent. As a matter of law, they should be allowed to use any of those predicts when at the end of the day, there's absolutely no evidence Mr. Pecker, Mr. Cohen, President Trump, Dylan Howard, or any of the others purported conspirators for this misdemeanor of state law had any criminal intent at the time that they were engaging in this conduct. Whereupon, at this time, senior court reporter Lori Eisenberg will leave senior court reporter as official court reporter. Proceedings. Miss Blanche. Mr. Blanche, by the way, there was no discussion at the October 2015 meeting about, this is Mr. Blanche speaking, about the catch-kill. Nobody said that. There was no discussions about financial payments that would potentially be made with respect to any stories. So you don't have evidence of any criminal intent or any criminal conduct at this supposed first meeting where the conspiracy is born and then played out over the next year plan. Then, when you look at the actuality, how the conspiracy played out, Karen McDougal, if the evidence is to be credited, she never even wanted her story out. She was looking to start her career anew, jumpstart her career. She wanted an arrangement with AMI so that she could be on the cover of magazines, write a column, not to catch and kill a story. While that's the words used by Mr. Cohen, and in the opening statement, that's not the evidence that came out in trial. That was demonstrably false story. Everybody agrees. So again, if there's some conspiracy to influence an election, for some conspiracy to illegally influence election, how on earth is keeping a false story from the voters criminal? So it's a false story that there's a decision made to pay off the person who's spreading the false story. That means that the false story is not being presented to the folks that are voting in New York State. That's not a catch and kill, Your Honor. Certainly not a criminal catch and kill. As it relates to Miss Daniels, AMI wanted nothing to do with that. There's lots of testimony about that. When it came to catching and killing, which is supposedly the conspiracy that's going to be entered into between Mr. Pecker, Mr. Howard, Mr. Cohen, and Mr. Trump, if there was really the conspiracy, AMI would have jumped out of the conspiracy. As you heard over the past several weeks, Mr. Pecker wasn't interested, Mr. Pecker was insistent that he wanted nothing to do with any kind of catch and kill with Miss Daniels. In fact, he led Mr. Cohen entering into an NDA with her. Mr. Cohen is not a member of the press. He doesn't own the National Enquirer. This isn't a catch and kill story, which is supposedly the conspiracy that was formed in 2016. So, the three separate incidents this jury heard about the grave conspiratorial criminal intent to the participants are not that at all. So the underlying predicts that give rise, that make this misdemeanor a felony. There's simply no evidence of any intent, of any criminal intent on any of the parties in 2016, 2017. And for this reason, the court should enter a verdict in favor of the defendant. Finally, we've been saying this for months. We've heard Mr. Cohen testify the past several days. There is no way that Mr. Cohen should let this case go to the jury relying on Mr. Cohen's testimony. And I don't think the people would disagree that without Mr. Cohen, there's no case. Meaning without his testimony last week and today, there's no case. And he's not only lied repeatedly in the past under oath, but he lied in this courtroom. And I'm sure that the people will say, well, he didn't really lie, he misremembered. But we put on irrefutable proof. Irrefutable proof. When he testified on direct about a phone call, and he remembers specifically a key part of this crime that took place. A key part is keeping President Trump updated. And he said it 19 times on his direct. And today, he said he talked to him about more than 20 times. That's obviously a key part of their story. He confidently said that on October 24th, when he had that call just after 8 o'clock at night. The purpose of the call was to have Mr. Sheeler give the phone to the president, and then the court. So you're asking me to find Mr. Cohen not credible as a matter of law, Mr. Blanche? Yes, absolutely. Because it wasn't just that lie, Your Honor. He also lied to the court repeatedly, for example, about his testimony in front of Congress and whether he said he never asked for a pardon. It shouldn't move the court that he continues to lie about that. I mean, the court has the transcript. The court has the evidence, the testimony that he put in front of Congress, where he said something that we know from the testimony at this trial is not true. And he still doubles down, the court. So you want me to take it out of the jury's hand and decide before we even get to the jury that as a matter of law, this person should not be worthy of belief, that it shouldn't be considered by the jury. That's what you're asking. Mr. Blanche, that's his entire testimony should not be considered by this jury. Absolutely. That's exactly what we're asking the court to do. Again, we didn't just catch him in a lie, Your Honor. He came in here with a history of lying under oath. Again, Your Honor, ruled before this trial, started with respect to that issue, Your Honor, said correctly he didn't appear in front of you. So it wouldn't be appropriate just based on past allegations of lying under oath. It wouldn't be appropriate to just say he can't testify. He testified and he lied under oath in this courtroom. And that consequence of that lie, if accepted by the jury, is that in a conviction, potentially. And so imagine that the court, you said his lies are irrefutable, that you think he's going to fool 12 New Yorkers into believing this lie. Well, Judge, it's an irrefutable lie. I certainly hope he doesn't convince 12 jurors. I would like to hear from the people, Mr. Colangio, the standard of the court, the standard, as the court knows, for the motion the defense just made requiring assessing the evidence is the light most favorable to the prosecution, assuming the jury credits the people's witness and giving the prosecution's evidence the full weight it might reasonably be accorded. So against this backdrop, there's just no argument that the evidence falls short of the standard that people need to show to defeat this motion. Let me address. I think Mr. Blanche made three key arguments. First is that there's no evidence of falsity because Mr. Cohen performed or provided legal services in 2017. The trial record overwhelmingly rebutes the argument that there's no evidence of falsity. Among other things, Mr. Cohen performed similar legal services in 2018 and was not paid. Then, of course, you have the People's Exhibit 35 and 36, accompanied by testimony of Jeff McConley, explaining those documents would memorialize and track these conversations of a $130,000 wire transfer to Keith Davidson into the exact $420,000 reimbursement that Mr. Cohen ultimately received. On top of that, you have admission in at least three other pieces of evidence we introduced. The People's 81, which the defendant signed and certified Office of Government Ethics form, which explains in the footnote, we pointed out on page 45 that the defendant reimbursed Mr. Cohen for expenses he incurred. We got People's 407G, I believe it was, which was a public statement from the defendant admitting the reimbursement of Mr. Cohen. We have a testimony from Miss Daniels, transcript 2903, where she acknowledges from civil litigation in California, the defendant acknowledged Mr. Cohen had to be reimbursed. The evidence this payment was for reimbursement and not for a retainer for legal services performed is overwhelming. And at minimum, a rational juror can conclude beyond a reasonable doubt that involves the ledger entries, the signed checks with check stubs, all contain false instruments. Mr. Blanche made a couple of arguments regarding intent to defraud. At least one of them touched on the first element of the CJI instructions, whether the defendant has made or cause a false entry in the business or his entries, because Mr. Blanche talked about the accounting staff and the normal operations of the accounting staff. As a matter of law, Your Honor, it's sufficient, more than sufficient, if the defendant set in motion the sequence of events that led to the false entry being made, and if those false entries were the reasonable foreseeable consequence. I lost my spot. Consequence of his action. So I think there will be no question related to the overwhelming evidence leading to the payment scheme that the defendant caused the false entries or intent to defraud. Again, Your Honor, you already held in denying the defendant's omnibus motion. As a matter of fact, the grand jury supported, at that point at least, 3 different theories of intent to defraud. The first was evidence of the general intent to deceive, and here the evidence in the trial record, including an overwhelming record of concealment. It supports general intent to deceive. The court also acknowledged general intent to deceive. The voting public also supports the element of intent to defraud. Then, of course, as Your Honor also held at page 19 of the omnibus decision, the evidence supports a showing of intent to deceive government regulators. On the last element, Mr. Blanche discussed the intent to commit, aid, or conceal the commission of another crime, Your Honor. There were weeks and weeks of testimony from witnesses who testified and whose testimony was corroborated by emails, bank records, contemptuous phone calls, text messages, and other documents of the conspiracy that was entered into in Trump Tower in August of 2015. That was then effectuated through unlawful means. The unlawful means include illegal corporate contributions to Karen McDougal, the excessive individual campaign contribution to Stormy Daniels. And then, of course, Your Honor, there's extensive evidence of false business records being created in the course of carrying out the conspiracy, including the false invoice from Investor Advisory Services to conceal the intent transaction between AMI and Mr. Trump, as well as all of the false documents that Mr. Cohen submitted to his bank in order to open both of the shell companies he intended to use to tender the transfer. There's a lot more. We don't need to give a full summation in order to rebut the information Mr. Blanche gave. The trial evidence overly supports each of the elements of the offense, and the trial order of dismissal is not warranted. The court, I'll reserve decision. Mr. Blanche, briefly, Your Honor, the evidence of there being any sort of illegality in this conspiracy, a conspiracy isn't conspiracy just because 3 people get together and talk. There has to be an illegal objective. False filings of AMI records doesn't qualify. False records years after the facts that there was a campaign contribution that Mr. Cohen ultimately pled guilty to, that shouldn't qualify. The evidence that came into this courtroom is really what the court should consider. You have no evidence of a catch and kill at the meeting. They're just evidence that of what reporters and politicians do every day during every campaign, and the people have turned that into the beginning of a conspiratorial agreement and relationship. But that's not what the evidence shown over the last several years. At the end of the day, then I'll sit down, you have a book of records violation where you have a legal expense. That's the entry that's false, supposedly. And you have the testimony, non-contrary, that Mr. Cohen was President Trump's lawyer 2017. So it's hard to imagine that book, how this was supposed to be booked by Trump, by Ms. Tarnoff, when she gets the invoice. How is she supposed to book that fact that the lawyer working for President Trump was his personal attorney, legal expense? So I'm going to finish with Mr. Cohen. I won't go on and on. In addition to what I already said, Judge, the exacting testimony that he gave this jury, and we crossed him on, but a lot of the objections were sustained. The exacting testimony that he gave about particular conversations that he remembered with President Trump in 2016, we never saw those. They're not in any notes of this with the special counsel, with the Southern District, or with the Manhattan District Attorney. That's something we talked about before. He definitely talked about in the grand jury and in meetings that were phone calls. There were conversations, and there were conversations. That's a lot different than what he said on the stand when he gave very specific recollections. That's something that's not something we knew about. Apparently the people knew he was going to do that. Under the law, if he's going to change his story like that, they should provide us notes of that. They didn't. That's another reason why his testimony should be rejected, Your Honor. Mr. Ken Colangino, Your Honor, as the court knows, and as defense counsel knows, we have received probably 100 pages of notes and conversations with Mr. Cohen. It is simply not that the case that his testimony at the trial is not reflected in the notes. The defense counsel had ample opportunity to impeach his by omission, where impeaching by omission was permitted. The court permitted it. Where it was not appropriate, the court did not allow it. There's no evidence, none, that his testimony in this court was new. One other correction. The false entries on the invoices, general ledger entries, and checks or check stubs were these payments that were falsely described as payments pursuant to a retainer for services rendered in a given month, not the legal expense standard. The court, thank you both. As I said, I'm going to reserve decision. See you tomorrow at 9:30. Mr. Blanche, can we approach? Whereupon the following proceedings were held. At sidebar, Mr. Blanche, I just have a scheduling question, assuming we finish at 10-ish, 10:15-ish. Are we going to go right to the charge conference or in the afternoon? The court, what is your preference? Emil, by arguing it, Mr. Steinglass, he's behind you, whereupon the defense counsel confer. Mr. Bove, whenever it's convenient. The court, I think we should take at least a short break so we can all properly prepare for this pre-charge conference. Unless there's a strong objection, I would actually like to come back at 2:15, do it in the afternoon. Mr. Colangio, no objection here. We were just conferring on the exchange of proposed language Your Honor was requesting this morning. We haven't had an opportunity to exchange that proposed language. The additional time will give us a chance to do that. The court, okay? Whereupon the case is adjourned to May 21st. I need a drink of water. All of that, I'm going to put this screen down so I'm not all whited out. Multiple screens. That was a lot to read, a lot to take in, and I'm processing it in my head now. Essentially, what happened is at the end of the day, the defense said that we should remove all of Michael Cohen's testimony. And then he spouted his reasons why. And then they came back and said, yeah, everything that dude said was misrepresented because everything that we have admitted is already there. So what we have is we have a pending answer from the judge. That would probably be the first thing that he comes back with to say if he's either going to strike Mr. Cohen's testimony or if he's going to let it stand. And then they'll go right into closing arguments. And I tell you, that's what I'm looking forward to hearing. Got to see a little good brief peek of it in this, this request for dismissal. I'm sure he's going to reference that he's going to say we tried to get it dismissed, but the judge wouldn't listen. That's when they get to grandstand and they get to say whatever they want. So like I said, I'm really looking forward to that. I may go back and read some of the testimony, of the pre and cross of but ask for it. If that's something you want to hear, let me know that you want to hear it, because these things, I swear, this one must have taken about an hour. These take some time. but they are interesting, and it's a lot better than just hearing what they're putting on television. Granted, then you have everybody else on YouTube that is commenting on everything that was said on television. This here, a no opinion, we're just reading the facts. We're just reading the words of what was said. We read the indictments, we read court transcripts. We don't interject. We don't put in our own opinion. But we do have a bias, and my bias is I want to see how they're going to defend this. This is a very interesting case. I want to see where it's going to go. I got a buddy of mine that I talk about this stuff with, and the way he's seeing it, the defense is going to win. All they got to get is one person to have it be a hung jury. So we'll see. But thank you all for listening. And if you do like this type of content, make some comments, like and subscribe, because we're going to be back. Closing arguments are coming, and I'm expecting some fire. I'm expecting some fire to come out during these closing arguments, because this is a big money game. Big money game. Thank you, and good night.